Good afternoon. Welcome to the Heritage Foundation and our Lewis Lehrman Auditorium. We, of course, welcome those who join us on all of these occasions on our heritage.org website. I would ask our guests here in-house if you'll be so kind to see that cell phones have been turned off as we prepare to begin. It will be appreciated. And, of course, we will post the program on the Heritage homepage following our event for everyone's future reference. Our internet viewers are always welcome to send questions or comments, simply emailing us at speaker@heritage.org. Hosting our discussion today is Ryan Anderson, our William E. Simon Fellow in Religion and a Free Society. In Heritage's Richard and Helen DeVos Center for Religion and Civil Society, Mr. Anderson researches and writes about marriage and religious liberty. He focuses on justice and moral principles in economic thought, healthcare, education, and also has expertise in bioethics and natural law theory. He is also the editor of Public Discourse, the online journal of the Witherspoon Institute in Princeton. He is the co-author with Princeton's Robert P. George and Sheriff Gurkis of the book, What is Marriage? Man and Woman, A Defense? His previous positions include assistant editor of First Things, journalism fellow of the Phillips Foundation, and executive director of the Witherspoon Institute. He earned his Bachelor of Arts degree from Princeton and is a doctoral candidate currently in political philosophy at the University of Notre Dame, where he earned his master's degree. Please join me in welcoming Ryan Anderson. Ryan.
Thank you, and thank you all for coming for today, which promises to be an outstanding discussion. Since we have a lot to cover, I will keep these introductions brief. In the past few months, we've seen federal judges declare state marriage laws unconstitutional in Ohio, Utah, Oklahoma, Kentucky, Texas, and Virginia. We've also seen state attorneys general in Illinois, California, Pennsylvania, Nevada, Oregon, Kentucky, and Virginia refused to defend their state marriage laws in the courts. Indeed, in a prominent New York Times interview last month, United States Attorney General Eric Holder strongly suggested that state AGs need not defend their state marriage laws. In some of these states, over 70% of citizens went to the ballot box and exercised their fundamental civil right, the right to vote, to define marriage as the union of a man and a woman. In doing so, they restricted no one's liberty, as laws defining marriage don't infringe on anyone's freedom. These laws reflect the truth about marriage as the union of a man and woman, husband and wife, so that as many children as possible can be raised by a mother and father. And yet, federal judges and state AGs have disregarded these citizens, their voices, and their votes. These events raise serious questions. What is the constitutional status of state marriage laws after the Supreme Court's Windsor decision in the Federal Defense of Marriage Act? What are the ethical obligations of state attorneys general to defend laws, even when they might disagree with them or have conscientious objections to them? And lastly, what's going on in Virginia? You will not find three people better equipped to answer these questions than those gathered here today on this panel. Our keynote speaker, the Honorable Kenneth Cuccinelli, served as Attorney General of Virginia from 2010 until earlier this year. Prior to that, he served in the Virginia Senate from 2002 until his election as Attorney General. Cuccinelli is a graduate of the University of Virginia and holds a law degree from George Mason University. Notably, he declined to defend a Virginia law while he was state AG, and will comment on that today. Ed Whalen is president of the Ethics and Public Policy Center, one of America's premier think tanks. At EPPC, he directs the program on the Constitution, the courts, and the culture, and he's a frequent contributor to National Review Online's Bench Memos blog. A graduate of Harvard College and Harvard Law School, he clerked for Supreme Court Justice Antonin Scalia and has worked in all three branches of the federal government. Carrie Severino is stuck in traffic. She is on her way. She's Chief Counsel and Policy Director of the Judicial Crisis Network and a frequent contributor to NRO's Bench Memos. She's a graduate of Duke University and Harvard Law School, and she clerked for Supreme Court Justice Clarence Thomas, and until March of 2010, she was the Olin Searle Fellow at Georgetown Law Center. Attorney General Cuccinelli will speak first, touching on all of these issues, especially as they bear on Virginia. Ed Whalen will then comment on ethical duties of state AGs in general, and then Carrie Severino will comment on the constitutional status post-Windsor of state marriage laws. We're in for a treat. Please join me in welcoming the panel.
Well, good afternoon. It is a pleasure to be back at the Heritage Foundation. Ryan, thank you for the introduction. I'm going to go quickly because I think there's an awful lot of opportunity for vigorous discussion on this topic or these topics, depending how you look at it. And so I will, not to be the guy practicing to do disclaimers on car commercials, but I'm going to move quickly through the material that I have, leaving I won't touch on everything because I'm sure we'll get to it in questions, and that Ed and Carrie are also touching on elements of this. So let me start with the standard for attorneys general declining to defend a law or a constitutional provision. Frankly, this can be stated in very clear terms, and understand we're not going to deal with the federal situation where you have arguably assaults on executive power. I'm leaving that aside. We will only talk about when the attorneys general determine that for reasons of law, in other words, they don't believe that what they are called on to defend is defensible, that they stand down in defending a statute or a constitutional provision. And that standard has been consistent at the federal level in terms of how it's been expressed for many years. It has not been any different at the state level. And to put it in simplest terms, what an AG is called on to defend must be blatantly unconstitutional. Not, I really, really want it to be unconstitutional, meaning as a matter of objective law, it is blatantly unconstitutional. And this standard, or a form of it, has been traced. Ken Klukowski and Kurt Levy have an article coming out in the next month or so, and they traced back all of the high-level public expressions of this. The first one appearing under President Ford, Solicitor General Lee, same standard. President Carter's Attorney General Civiletti, same standard. Ronald Reagan's Attorney General Smith, same standard. Notably, also Ronald Reagan's head of the Office of Legal Counsel, a gentleman by the name of Ted Olson, who has an interesting different role in the marriage cases. And then nothing under President Bush at that level. Twice under President Clinton, Solicitor General Days. He is the one who used the actual phrasing of blatantly unconstitutional. And then Clinton's last Solicitor General, Seth Waxman, who has also written on this subject. All consistent. And that standard is held throughout history at the federal level all the way up until 2011, when Attorney General Holder announced that they would no longer, they didn't make an initial decision, that they would no longer defend the Federal Defense of Marriage Act. And that is the Windsor case. Critical for what we're talking about is the Perry v. Hollingsworth case that addressed, or didn't address specifically, a state marriage amendment, California's. This has been the only standard that I'm aware of throughout American history until Holder's change of the standard, which he tried to disguise as not a change of the standard in 2011. That's a long time on a bipartisan basis for a legal standard of performance to hold up. And I think we need to look very carefully when we change such a standard. And here it is clearly not being done for reasons of law. Let's not beat around the bush and try to rationalize it. This is the ends justify the means rationale. And it is casting the law and the rule of law aside for a very short-term desired political outcome perceived as a gain. That's what's happening here. It is very rare for an attorney general not to defend a law or a constitutional provision. As Ryan mentioned, in my 4 years, there was only one instance of it. And it's a useful study. I'm going to talk more about it at the end. I'm a strong accountability school choice person, and the law that we could not defend was one that contravened rather directly a state constitutional provision that would allow the state to step in and take over a failing school in a local school district. And I'll explain why that was problematic toward the tail end of my remarks. That was the only instance. And realize the concept is one that I like. I favor it. People who don't understand the role of the AG on sort of in my part of the political spectrum were confused. Well, why are you attacking this? I'm not attacking it. We talked to legislators when this was going through and explained to them how they could achieve this consistent with the Constitution, and they chose not to go that path. Frankly, if I were a legislator and my lawyer had told me I don't think this is constitutional, I'm not sure I'd want them defending my position anyway. And so we stood aside for that. Once in 4 years. It took my successor 12 days. And it's because it didn't crop up. He was not telling the truth during his campaign. He wasn't being fully honest with people. And he was seeking to go out and pull what amounts to a political stunt. It's sad to see that as someone who respects the position of Attorney General the way I do. The federal Attorney General is different from all other cabinet members, something to keep in mind. All the other cabinet members really truly do work for the president. When it comes to these sorts of questions, the Attorney General at the federal level's first duty is to the law. That is hard for the average person to understand, but that is the reality of the uniqueness of the Attorney General's office. And there's a similar form of uniqueness at the state level as well. The most famous example of this being fulfilled was when Nixon ordered his Attorney General to fire Cox, the independent prosecutor, and he refused to do so, believing that was inconsistent with his legal obligations, and he resigned. And his deputy refused to do so and resigned. And each of them had, in fact, in their confirmation hearing, said they would not fire Cox or the independent prosecutor without cause, and there was no cause. And that's what the law said, you needed cause. And I don't want to get into an independent prosecutor argument, but they saw their duty to the law and not the president. And they were right as far as that analysis goes. State AGs are different. They have different bases for authority in each state. Some have common law authority. Some have purely statutory authority. Most are probably mixed in some way in terms of where their authority comes from. They defend laws and constitutional provisions. The federal Attorney General never has to defend the U.S. Constitution against anything, well, except attacks on it, but not in the same way that we're talking about today, where you have competing constitutions, state constitution that is being assaulted as inconsistent with the federal Constitution. The federal AG never is put in that position. It's a subject that is unique to the state AGs. That's important for a number of reasons. One, we have to recognize the distinction, but two, Ryan alluded to this, when it comes to marriage amendments, the people voted on these. In Virginia, like most states, the executive branch has no role, zero role in amending the Constitution. The legislature passes it twice on both sides of an election, and it goes to the ballot, and the people decide. And in Virginia, the marriage amendment passed 57-43, and that was back in 2006, and Mark Herring voted for it. A worthwhile consideration. At the federal level, there are only laws that may not be defended, and in those, the executive branch had a role, signing or vetoing. So they're in a different position. When it comes to Virginia, Mark Herring did not merely stand aside and not defend Virginia's constitutional provision, as happened in Perry v. Hollingsworth. The California famously didn't step up to defend its own constitutional provision. He attacked it. This is, to my knowledge, and I am welcome to be corrected on this, but Mark Herring hasn't provided an example of it. I am unaware, prior to his act, of any attorney general in America ever doing this. Now, he cited lots of examples in his 7-page rationalization he submitted to the court for why he was changing Virginia's position. If he truly believed the constitutional position he held, his proper course of action was simply to step out of the case. Instead, he switched sides and is actually attacking Virginia's constitutional amendment. That is absolutely unprecedented. The closest example he came up with, he used now Chief Justice Roberts from 1989, where the United States didn't defend a particular law and filed an amicus brief suggesting its unconstitutionality. An amicus brief is not a party position attacking the law. One may argue that that's stretching it, but that is nowhere near the position of actually turning on your client. And all the lawyers in this room understand the significance of that. The steps that Herring took resulted in blocking a meaningful defense from occurring. He stopped other parts of Virginia government from being able to step up and defend the law. When I stood down from the one example in my tenure, we stood aside so others in Virginia government who believed there were arguments to be made, passing what I euphemistically call the straight face test for constitutionality, could do so. And that is the proper role for an attorney general. What Herring did is indefensible under the law. It's not defensible. Remember, he voted for the marriage amendment. He clearly understood that there are arguments to be made on behalf of supporting the marriage amendment, or presumably he wouldn't have voted for it back in 2006. But he did. He clearly thought it was defensible. And now what he does is obfuscate, using me actually as an example. Well, Cuccinelli did this. No one has ever done this, as it phrased by Mark Herring. He literally stands alone in a history, and he has to obfuscate. He has to use language that sounds subtly close to other things, like Holder is doing. The example in my case, and then I'll turn the podium over to Ed, was quite simply, I told you, the state stepping into a failing school. Here is the critical part of the state constitutional provision. The supervision of schools in each school division shall be vested in a school board. That is referring to the local school board. Not a lot of wiggle room there, as we told them as they were passing this law. And so when they passed it, we stood aside for others to defend it, because I do not believe it is defensible. That's still being litigated. We'll see. The rule of law itself is at issue in this discussion. The left has fully embraced an ends justify the means approach to virtually everything in public policy today. That is the trend they're taking. Lying is acceptable, rationalization is acceptable, and this leads to chaos in the law, absolute chaos in the law, and tyranny in the exercise of power. Once these boundaries are gone, tyranny is the natural course to result. And it's being brought on by attorneys general who are supposed to be a bulwark against exactly such undermining of our constitutional republic.
Thanks very much, Ryan. Thanks, Attorney General Cuccinelli. It's great to be here with you. I'm going to focus my remarks on a very specific issue. I want to be precise here. I'm going to be looking at the duty of a state attorney general to defend state laws against a challenge under federal law. This question is conceptually a tad distinct from the duty of a state attorney general to defend a state law against the state constitution. It's also conceptually a bit distinct from the duty that the U.S. Attorney General has. As it happens, as Attorney General Cuccinelli indicated, on all three of these situations, by somewhat different paths, you end up in the same place. But I'm going to be focused now on what I think is the clearest, simplest case, the ethical duty that Virginia Attorney General Mark Herring and others have violated, which is the duty that a state attorney general has to defend state law against challenges under federal law. This is really legal ethics 101. And I'm not sure I've seen any legal ethicist dispute these basic propositions. For starters, under well-settled principles of the American adversary system, a lawyer is ethically obligated to represent his client's legal position zealously in court. That means, among other things, that if there are non-frivolous arguments that can be advanced in support of the client's position, the lawyer should advocate that position when it's in the client's strategic interest to do so. Under narrow circumstances, a lawyer may withdraw from representing a client in a matter, but a lawyer may never fail to advocate a defensible position that is in the client's interest simply because the lawyer personally believes it to be legally incorrect. Now, when we come to this situation of a state attorney general, by virtue of his office, the state attorney general is a top lawyer for his client, the state and its people. The legal positions of the state and its people are quite simply set forth in its laws, including provisions of the state constitution and state statutes. The attorney general's obligations as a lawyer therefore require him to vigorously defend any of those laws against challenge under federal law, so long as there are non-frivolous grounds for doing so. That is a very, very low bar. Now, it doesn't require the Attorney General to defend laws that are clearly invalid under existing judicial rulings, but the Attorney General can't refuse to defend a state law because he's formed his own personal judgment that the law violates the federal Constitution, or because his best prediction is that that's how the courts will rule. If, for reasons of conscience, the Attorney General can't defend a particular state law, he should step aside. Someone else in his office can then step up to defend it. Now, the one argument that I've heard different state attorneys general make is, but I've taken an oath to defend the federal Constitution. Let's consider that briefly and see what merit that has. Every attorney in this country takes an oath to defend the federal Constitution. As part, look at the oaths for admission to the state bar. Look at the oaths for admission to federal courts. No one has ever suggested that because I, as an attorney, have taken an oath to defend the federal Constitution, that when I'm defending a client in court, I should be elevating my own personal views as to what the Constitution means over the client's positions. That's an absurd position that no one would ever embrace in any other context. It's also important to recognize that under the federal Constitution, it's not just the Constitution itself that is the supreme law of the land. It's also federal laws made in pursuance thereof and agency rulings, orders that are consistent with that. So if you really took this position seriously, that it's this oath that somehow gives the state attorney general an excuse to not represent his client, that would mean that any time a state attorney general believes that an agency order trumps a state constitutional provision, he should not defend his state constitutional provision against that order. Again, that just turns our system upside down, and I don't think there is any legal ethicist in the country who would defend the propositions that underlie what the state attorneys general are doing. Now, of course, all of this takes place, as Attorney General Cuccinelli indicated, in the context of the broader derelictions when it comes to defense of marriage. Attorney General Cuccinelli mentioned Eric Holder and the Defense of Marriage Act. Of course, first, the Attorney General pretended to defend DOMA while in fact sabotaging it, which is in many ways is, I think, a even deeper violation. Then he came up with his poor excuses for abandoning the defense. Of course, you see the law firm of King and Spalding, where former Solicitor General Paul Clement had been, abandoned its client as soon as it faced political heat. And you've seen Attorney General Holder actually incite, not just strongly suggest to state attorneys general, but positively incite them to not to defend state marriage laws. And it's no coincidence that these derelictions of duty are occurring in cases challenging marriage, because what we see is that when advocates of redefining marriage to include same-sex couples resort to the courts to invalidate marriage laws, they perceive that victory depends on stigmatizing as irrational bigots people who hold the same position on marriage that nearly everyone throughout American history, including President Obama until just about yesterday, held. What better way to signal that somehow this cause is beyond defense than to bully or invite compliant state attorneys general to throw in the towel. And I think what we see here is an in part, unbounded political ambition on the part of state attorneys general, who are being told by their base, you better do this or you have no future in state politics. Indeed, I'm told that in the case of the Kentucky Attorney General, who appeared, weeping to explain his position, that just a couple days before he had been told exactly that. Now, of course, we all recognize that there's this inherent tension that an elected official is going to have, especially one with ambitions, and it's perfectly proper for a state attorney general to have political ambitions. But the rule of law requires that there be bounds on that, that there be this realm of impartial decision-making that is not simply politicized. And if state attorneys general come to believe, as Mark Herring purports, that they have discretion to refuse to defend state constitutional provisions and statutes that conflict with their own subjective legal judgments, then state laws will exist only at their sufferance, and you're going to see a deep, deep politicization of the rule of law. I think we'll all be the worse off for it. I'm pleased to see that the Republican Attorney General's Association has stepped up and criticized Attorney General Holder for his irresponsible statement. But my question is, where is everyone else? Where's the ABA that somehow went ballistic over presidential signing statements, but from what I can tell, hasn't over this gross violation of duty? Where are the state bars that are saying, you, as Attorney General, have an obligation to do what every attorney has to do with respect to his client, vigorously defend its positions? So there's this silence that I think is really the result of, in part of intimidation, in part, obviously, for many people, of agreement with the political ends of the other side. But it really is shameful, and I think it's deeply damaging to the rule of law. So with that, I will hand the baton to Carrie Severino. Thank you.
Thank you. So my task here then is to speak a little bit to the specific way this is playing out in the context of the marriage debate in this country. And I think for that, I'm going to do a quick review of the Windsor and Hollingsworth cases, because that is what is at least being used as a fig leaf to drive this general dereliction of duty and the general move, kind of tidal wave in the lower courts of overturning state laws that define marriage according to, as being between a man and a woman, according to as it has been traditionally defined. So obviously, Attorney General Herring is not a one-off in this case. This is a part of a larger process. So there were two cases that were decided last term on same-sex marriage. One of them was the DOMA case, which is the one that seems to be getting the most play in these, and that was Windsor versus United States. That involved, for those who aren't familiar with the case, is a New York couple who were married in Canada, moved to New York, and then one of the women died. It was a lesbian couple who had been married under Canadian law when New York did not have legal same-sex marriage in its state, and then they were claiming they wanted to be able to have inheritance go according as if they were married and not be subject to a state tax under the federal gift tax laws. If they were married, that would be able to pass more easily between the couple. And they claimed that the Defense of Marriage Act violated their rights. What the court held in that case, it was a very confused decision. It involved actually the same problem we're seeing today, because you had the Attorney General of the United States, the Solicitor General, in that case, the United States, who was appealing the case on one side, saying we are aggrieved by the decision having where DOMA was declared unconstitutional below, but at the same time, but also arguing against it in the court. So it was one of these trying to play both sides of the table things in the appeal process in general. But then the court's decision also was very confusing. And so in some ways, I suppose that you could almost forgive the lower courts from coming to some of the confused decisions that they've come to, because they're working with a difficult starting field. The Windsor decision spent a lot of time talking about the importance of the preeminence, really, of state government and state law in determining domestic law and marriage. It talked in glowing, effusive terms about how important this is, how historical that role plays, and how what's going on here is the federal government is trying to, in a kind of unprecedented move, take something broadly across the board away from states and singling out a particular class of citizens that a state marries and saying that they're not going to be considered married. The way that Windsor talked about it, said it was actually purposely disadvantaging that class of individuals, and so they then segued from there to the notion of animus, which has come up a lot. So animus is important because under pre-existing law, we have, if the government enacts a law simply because of animus, then it makes it very easy to overturn it because it doesn't even survive allegedly rational basis scrutiny because animus is not a rational basis for law. So the Windsor decision talked about the importance of state law, but it also had one line saying that there is no state law is immune from constitutional scrutiny. Nonetheless, it cites Loving versus Virginia, the miscegenation case. So yes, state laws still are subject to the Constitution, but the state nonetheless has a very central role. So apart from where it violates the Constitution, the federal law must follow state law. And it also pointed out the what it viewed as a intolerable position of having a state have two different marriage regimes. So if a state, for example, had a same-sex marriage in that state, and then the federal government did not recognize those marriages, it would be confusing, it would be problematic, it would be discriminatory toward people who were accepted by the state as married but not by the federal government as married. It also talked about the state conferring dignity as an exercise of its sovereign power. So this is sort of, Justice Kennedy wrote this opinion, so this is, I could quote more, but you can imagine the rhetoric going on here. But that the state has this power to confer dignity, and therefore the federal government taking away something strikes at that dignity, and indeed was found to violate Fifth Amendment due process. Now, the decision never talked about exactly what type of scrutiny was being granted, whether it really was a fundamental right that was at issue here, which would be hard to imagine since fundamental rights normally have some sort of historical basis in them and are not historical novelties. But the court kind of hinted at all those things. And then we have a trio of dissents that ran the gamut from Justice Scalia's parade of horribles, talking about how the logic of the Windsor decision, to the extent that it can be called logic, points in the direction of overturning state marriage laws just as much as it does the Defense of Marriage Act, because any of them could be conveyed as being equally have equal animus, or if you just determine that anyone who's opposed to this is inherently irrational and bigoted, then of course all of these laws are inherently rational and bigoted and will fall easily. He also, and of course all of them contested standing. Chief Justice Roberts went to great length to try to cabin the decision and said this decision is not intended to speak to the broader issue. And the decision itself even has a kind of a throwaway line almost at the end saying this is only limited to people who are in valid marriages, state marriages. It's not meant to go beyond that. And Justice Scalia reiterated that as well in his dissent. He said the logic of the decision is clear. It looks like it's going to apply elsewhere, but by its own terms, it's very easy to distinguish. You can distinguish this case if you want to. And Justice Alito, along the same line, said that this is incorrect. So the states, in following on this case, I mean, there are too many to cite right here, but going down the list of the decisions that have been made in state courts and in federal district courts, it's very clear the direction that they are taking. They generally cite the one line talking about Loving versus Virginia, that state laws are in fact still subject to the federal Constitution, and they cite the lower court decision that in earlier Baker versus Nelson, an earlier marriage case, Supreme Court case, isn't valid anymore, and that the law has moved on from there. And then they cite Justice Scalia's dissent, saying, look, this is just as clear as day, just like Justice Scalia said in dissent, that this decision has obvious implications for overturning marriage laws across the country. There's a lot of problems with that. First of all, dissents, of course, are sort of beyond dicta. They're not only held by a minority of the court, but they're the minority that didn't win. So a defense construction of the main court's decision certainly is an admission of the opponent, not of the majority itself. But that's something that all these states seem to rely on. In particular, it's interesting to see that there are cases like the one in Ohio, in the Obergefell, I think is how it's pronounced, case, where Ohio was forced not to necessarily change its own marriage laws, but to recognize out-of-state marriages, which in fact turns the Windsor decision on its head. Windsor talked about how can we have dual marriage regimes in a state, and the Ohio case did just that. Windsor said that states have this preeminent role in being able to define their own marriage law and their domestic law and policy, and this Obergefell case said no, in fact, other states can impose their own marriage law on what was formerly perhaps the sovereign state of Ohio. So, they've taken dicta from the majority and even dicta from the dissent and used that to create a wedge and turn the decision on its head. Now, the Windsor decision it's not actually clear entirely what the grounds were, because it said it didn't rely only on federalism, and it said it doesn't actually state a standard of review under equal protection review, but it certainly echoed these federalistic principles that have now been undermined completely by the cases. The other case that was decided in union with it is actually the case that's more relevant to this whole issue, which is the Hollingsworth case. And in that case, as you probably are also familiar, the district court in the Northern District of California determined that California's state constitutional provision defining marriages between a man and a woman was unconstitutional under the federal constitution. After that happened, the governor put his hands up and said, "Okay, I give up, and we're not going to continue defending this law." And so the proponents of that constitutional referendum were granted by California the right to bring this case and appeal it to the Ninth Circuit and then to the Supreme Court. What happened ultimately is the Supreme Court determined that when the Attorney General and the governor stepped out of the case, actually there was no party left that had standing in federal law to bring the case. So the proponents, which under California law, as per the California Supreme Court, did have the authority to do that, were not permitted to bring the case in Supreme Court. That gave the governor and the Attorney General effectively the right to lose the case by default on purpose. It was sort of an effective veto of any law that they chose not to defend, because at least under the system that's in place in California, there's no one left who can defend it in federal court. So all you need to do is find a law that your governor or your attorney general is unwilling to defend in court, and you will win by default every time, and there's no way to actually appeal that loss according to where we are. Justice Kennedy, who is in the majority in the Windsor opinion, wrote a vigorous dissent in the Hollingsworth case, and interestingly, he talked about particularly the initiative process, which was used here, how its goal was to circumvent the politically effective political officials, because perhaps the general populace didn't trust just these individuals who had been elected by 51% of the people in a certain election. They wanted to have their specific views on a particular issue known, and so they wanted to circumvent that process. This gives those same elected officials a veto power over that process. But actually, I think the implications are broader than that, because it applies not only to laws that are passed or constitutional provisions passed through an initiative or a referendum process, but actually could really apply to any law, as we saw, for example, in DOMA, a law that was passed by the Congress and signed by the President that had the same sort of result happen because of the dereliction of duty. So where are we in terms of other states? We've seen that California now, because the governor and the AG stepped back, is by default stuck with this lower court decision that overturned the state constitution. Virginia, as we've heard, obviously, is a similar situation. There are 25 states now that have maintained the traditional definition of marriage. Only 2 of those are not currently involved in an active challenge, at least as far as I can see, and 21 of them even have that as part of their state constitution. So we're talking about states that have their most fundamental level of state law defining marriage this way. In those states, 17 attorneys general are actually defending the law. So we have 17 of the 21 attorney generals who are actually defending it. Most of those are Republican, 13 are Republican, but there are, to their credit, 4 Democratic attorneys general who are defending laws in those states, so that's reassuring. And 2 of them are not. In Pennsylvania and Kentucky, they're not actually defending the law. There's also states that have civil unions, the four of those states, all of those are under challenge, and in those, we have 2 Republican AGs who are defending the law and 2 Democratic AGs who are not. And then we have 9 more states where there are courts that have imposed a redefinition of marriage. And those ones are the ones that are actually, the decisions have gone through finally. And you can kind of see that just by the distinction in the rate of refusal to defend, what the effect often is, because in those half of them, the Attorney General did not defend the law. So it seems obvious, but of course, when an Attorney General refuses to defend the law, it's more likely that a court is going to not uphold it, which of course is part of the goal. So Virginia is interesting because it's the only state that has actually changed its position. A lot of states in the Hollingsworth and Windsor cases filed amicus briefs defending the right of states to define their law, and Virginia actually turned around from defending the state's rights to going back. So recommendations in terms of looking at the sweep of how things are going in the marriage context in particular. I think there's a real need for states that don't have a system to appoint an amicus or have a system for someone to step down and offer an alternative group to defend a law, really ought to think about doing that if they want their laws, particularly in marriage, but frankly on any other topic, to be defended vigorously at the federal courts. If this pattern repeats itself in other areas, and I see no reason to think it wouldn't, I can see that being a broader issue. Because unless there are attorney generals that are willing to defend those laws, the people of those states and the laws of those states deserve someone to step up for them. So, thanks.
Thank you. All 3 of those presentations were excellent. We have about 15 minutes for questions and answers. We have people who are watching us online, so please wait until the microphone comes to you so they can hear your question as well. And it looks like there's a question right in the back.
Thank you. I think James Young, National Right to Work Foundation. I think this one goes for you, General Cuccinelli, but I certainly welcome the comments of anyone else. I guess I asked at this point, as a practicing attorney, the same question Lennon did: what is to be done? What do we do about a Mark Herring who has nakedly violated? I mean, one could suggest that maybe the House of Delegates should have impeached him. I know it's been suggested elsewhere. I think he should be disbarred. Has anyone filed bar charges against him?
Of course, in Virginia, that's not public, but given the discussion, my understanding is the answer to that is yes. Having been a practicing attorney in Virginia for quite some time, and my experience with the bar actually taking action against lawyers who are on the wrong side of the standard of professional ethics is not encouraging. And when you throw in the political nuclear bomb that is frankly being relied upon as cover here, my expectation is they will do nothing, even though rather obviously you literally have a lawyer attacking his client. I have a legal ethics opinion. It's that long, so you can kind of see. I'll actually read it because it's so short. Virginia Commonwealth's attorneys are our prosecutors, our local prosecutors. They are elected. They are not all full-time. We're almost to all full-time now, but not quite. So this is over 30 years old, and I'll translate from legalese. It would be proper for a part-time Commonwealth's attorney to prosecute, and that means civilly, a 1983 action challenging the constitutionality of a state statute. Now, this is in his private capacity, not in his capacity as a prosecutor. To carry forward a 1983 action challenging the constitutionality of a state statute under the described circumstances, and there are 2. The attorney has no duty to enforce this statute, and named defendants will not include any persons in the state government for whom the attorney must provide legal representation. Double whoops. And, I think any lawyer who sat down and thought about it, if you took the political incendiariness out of this, would come to this conclusion. It's not surprising or shocking, and yet I don't think anything will happen in that regard. To the extent there are going to ever be consequences, I think they will be when he does exercise his ambition, which clearly was driving this. I mean, he was sending out fundraising emails. No, petition emails. You can't raise money during the General Assembly session in Virginia. He was gathering names literally upon filing. And as I said, this is indefensible from a legal standpoint, and it can only be understood as an act of political violence to our legal system that is driven purely by political considerations.
I agree with Attorney General Cuccinelli that state bar complaints in different states are unlikely to yield good results precisely because the state bars themselves are so deeply politicized and corrupt. That said, I think it's essential to make those claims and to expose what's going on with these state bars. So when somewhere down the road, someone follows this precedent and the state bar seeks to act against that person, say for a less politically popular cause, you see the inconsistency. So I sure hope that efforts are made to disbar or otherwise discipline these state attorneys general, though again, I have no illusion that those are likely to prevail.
Other questions? Yep, on the left-hand side.
I just got back from California, where I proudly voted for Prop 8 along with 7 million other voters, and we overwhelmingly passed it by, I think, by 1 million votes. And Mr. Attorney General Cuccinelli, I think it was our Attorney General or an unjust judge overturned it. Also, I know of a private employer who had made a contribution to Prop 8, and the anti-Prop 8 protesters were at her restaurant on Beverly Boulevard, and I think that was actually in the newspaper. And don't we have enough violations of private rights?
Well, I would just comment that my view is that the left, while preaching tolerance, is the most intolerant portion of our society, and they demonstrate it rather viciously with great frequency. You've cited one example, but it is not unique.
I'll just add to that. There was intense bullying across the state of folks who supported Prop 8. I think it was Tom Messner here at Heritage who produced a great report on that. And unfortunately, the lesson that's being drawn from all this is that bullying works. That's really a lesson that's been drawn, and you can see more and more of it as a result.
And I think it also follows again from the casting of this argument in terms of animus, and rather than engaging on the issue and admitting, as I think classically liberal people ought to be able to do, that good, well-intentioned people could come to different conclusions on a hot topic like that, in being inclined to launch ad hominem attacks, like that the other sides are all just bigots and evil people, does encourage that kind of behavior of treating them as such.
If I can make one comment, because Carrie's touched on a subject that particularly related to Justice Kennedy is a focus, and that is the presumption, arguable presumption by the court that the only basis for advancing DOMA was animus toward same-sex individuals, toward homosexuals. I think Mark Herring and the president offer rather dramatic examples that is not true. Mark Herring in 2006, as a state senator, I was in the state senate with him at the time, voted to put the protection of marriage on the ballot. Mark Herring did not say at that time, nor would he ever admit, and nor do I believe it would be appropriate for him to, that he had any animus toward homosexuals. And nor do the vast majority of us, myself included, when we support that course. But he offers us a rather candid example that he's now in a different legal position. Look at the president, who opposed same-sex marriage until very recently, at least publicly, and surely our courts would not suggest that his opposition, let's look at him personally, was driven by animus. I wouldn't. I don't believe his flip was driven by animus. Political calculation, yes, but that's not animus. And it is very important for the courts to be driven off of that position. And by that, of course, I mean by argument. But we have real live human examples now in this system we're talking about that give us the answer to that argument.
Assertions of animus are routinely a substitute for legal argument.
It's the old ad hominem attack.
Ilya Shapiro.
Hi, Ilya Shapiro from Cato. I support same-sex marriage, but I agree fully with the analysis presented here about the duty of attorneys general. I have kind of a practical question, and setting aside, I think, what was a bad decision in Perry about standing to defend laws that otherwise go undefended, wouldn't it be better to have someone who actually supports the law, defending the law, rather than a quarter-hearted at best Eric Holder, Justice Department?
I mean, Justice Kennedy mentioned that in his dissent. He said, well, it actually, we should encourage, it would be better to have a system as California had set up until the Supreme Court just declined to recognize it as valid, where the proponents of Prop 8 were the ones defending it rather than, that's why I think it makes more sense, actually, for states to think seriously about trying to figure out how to set up an alternate regime, because the Hollingsworth decision suggests that if there had been sort of a statutory or state constitutional regime that gave that authority to a different person, that they would have acknowledged that as conferring standing. It's just because of the way it came about, and maybe because they didn't trust the California Supreme Court. A good instinct, I agree, but maybe they didn't like that method of doing it. So I think it would be useful to have real people, just as the Supreme Court in many cases, if the government, for example, confesses error in a case or isn't fully advancing the case, if there's a party that's not fully advancing it, they'll appoint an amicus to argue it. And I think
As they did in the healthcare case.
Yeah, exactly. So it would be great for courts to be doing that, and maybe even when it's suspected that an attorney general is half-heartedly arguing it, courts should be more aggressive in that, given the risk.
I'll just say it's a very sorry situation when we're in, that we have a legal culture in which attorneys don't understand that their obligation is to represent the client's interest, whether or not they personally agree with it. And I mean, I understand the sense behind your question, Elia, but to acquiesce or accommodate that by suggesting that we sort of build some sort of alternative structure so that when attorneys general aren't going to do their job, someone else will. Again, I understand that sentiment, and I'm supportive of it. But how complicated, is it to get attorneys to understand? What do they learn in law school these days? I mean, it's the most basic proposition, and I think we need to do what we can to restore respect for that and to find ways to punish those who don't live up to it. Now, that said, I mean, these are politically savvy attorneys general who do what they do because they made the calculus that politically they'll be rewarded for it, just as Jerry Brown went from state attorney general to become governor again. I'm sure his betrayal of his oath of office wasn't an issue at all in the gubernatorial campaign. But it's really up to lawyers, it's up to the ABA, it's up to state bars to fight against this collapse of the understanding of the responsibilities of lawyers.
Hadley Arcus.
I'm trying to think. I think Lincoln could provide a key here. When we did the Defense of Marriage Act, we were arguing for Congress to take its role in offering guidance to the courts that the political branches had an obligation to reach judgments on these matters. To take what John Marshall established in Marbury was that the courts had to make judgments on these things as cases came before them, but they're not the sole exclusive interpreters of the Constitution. Barney Frank at that moment said, "I think this whole thing is unconstitutional." We said, "Congressman, you make our very point. It's your position to make that." Now, Lincoln took the view that he would respect the outcome of Dred Scott in regard to those litigants. He would not be obliged to accept the principle if anything else came before him, but he'd have to respect that decision. On the matter of the Fugitive Slave Clause, he'd have to respect that. He'd bite his lip and defend it. And Russ Hittinger made the point that if the decision of the court were regarded as something woven into the text, Lincoln could not have stood up and taken that oath on March 4th, 1861 to the Constitution that incorporated the Dred Scott decision. And so I think the understanding would be that, yes, you have a judgment to make. You could veto that law. But after that, if it's in the law and if it's in your Constitution, Your obligation is to defend what is there. Right? Other than that, what you've done is given them an extra veto power, or else you have, as found in Kerry and the Hollingsworth case, you have barred other people from having standing to defend your own law.
Well, and I would just comment that, consistent with what Ed had mentioned, if you're going to run for Attorney General, this is part of the job. If you're not willing to do it, you ought not run. It's that simple. And, it's been a while since I read it, but I believe Justice Scalia has written on the death penalty. And of course, being Catholic, there's debates about the appropriateness of the death penalty. It's not contrary to Catholicism, but it's a tough squeeze. And so the question to Justice Scalia is, how do you uphold death penalty cases? And his answer is, because I trust in the process and I act with fidelity to the process, and I know how to change that law. And every Attorney General does. Mark Herring knows how to get that changed. He can get a vote out to go the other way from how he voted. But we commit to that when we run. When you run for governor, when you run for Attorney General, you're signing up for the whole package. The first thing I was confronted with as AG was defending George Mason University's outrageous gun restrictions, which were just barely inside the boundaries of the Second Amendment, but they were. And we defended it zealously. And for a year and a half, I took a beating from my Second Amendment supporters because it's my client. I can't go out and say, hey, my client's crazy. You can't do that with a client. Again, to Ed's point about respecting the role of a lawyer, when the case was over, I could stand in front of them with some chicken wire, but would stand in front of them and make the point as to my duty to defend as an Attorney General, even though I didn't agree at all with the policy. But it was defensible, and I signed up for that. And, I just see the abandonment of any principled foundation here. And there's a reason I commented that this leads to chaos in the law and tyranny in the exercise of power.
But just to be clear, it's consistent with the natural law position underlying the regime of law itself, that
Yes.
once the laws are in place, it's your obligation to follow them until they've been changed in a legal way.
I agree. And I think, frankly, we would benefit long-term, not short-term, from more reference to the natural law foundation upon which all of this is built.
And again, there may be situations in which someone has a actual conscientious objection. And in that case, our legal system recognizes you step aside and someone else in your office takes on the responsibility. You don't remove your office from the role of defending the law. It's your personal conscientious objection. You personally step aside and someone else steps in to defend.
Hans.
We've been talking about lawyer ethics, but judges also have ethics that govern them, the judicial canons. And isn't the judge, for example, in the Virginia case, who allowed the Attorney General to switch sides and start attacking, isn't that judge violating judicial ethics by allowing that to continue and not doing anything about it?
I don't know the particular answer to your specific question, but certainly it's arguable. But I don't see any judges anywhere. First of all, judges are the most reluctant of all lawyers to initiate disciplinary action, and by my observation. They'll hold you in contempt if they don't like what you're doing in their courtroom, but it is the very rare instance when I can think of when judges, even though things have happened right in front of them, including one that I was involved in the 90s where I had another side behaving in ways, standing in front of the court that were rather obviously unethical, and the judge was mum on the subject and intended to be mum. They do not want to step into that. I think they perceive themselves as then taking sides in litigation by dint of that perceivable attack. My view of it is the folks who put themselves in that spot have brought it on themselves.
It seems like it's clearly legally incorrect, if nothing else, but it's unfortunately, again, something that the Windsor decision gives them some cover for, because in that case, as the attorneys pointed out, the government was filing a motion to dismiss that requested them not to dismiss the case. So courts have put up with absolutely nonsensical and absurd results from this kind of behavior up until now. And if the Supreme Court is willing to sanction it, then it's going to be hard to expect that the lower courts are going to step out and really sua sponte, call a lawyer under the carpet for that kind of behavior.
Yeah, there's an awful lot to fault the federal judge in Virginia for, including not recognizing the difference between the Declaration of Independence and the Constitution. But I frankly, I don't see what she should have or could have done here, nor is it clear to me what the basis would be for saying that she acted unethically and in acquiescing in the state's change of position. I think this really is where we count on lawyers to live up to their own obligations and count on state bars to enforce the rules when they don't.
Unfortunately, we are out of time. I believe there are sandwiches outside of the door to the left, so please join us for a light lunch afterwards. But before you do, please join me in thanking our panelists.